We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist, and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these 2 books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell. In 1985, there was only about 1 line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion banks. For those who don't know, motions are documents filed with the court that says that the prosecution has some evidence that should not come in, and here's why. And here's all the law and the cases having to do with that issue. Oh, and by the way, we have some evidence that should come in. Here's the case law and statutes which explain why it should be allowed in. Julie, with her exceptional writing skills, has developed our motion bank. We have probably over 100 motions that have to do with every major evidentiary issue that comes up in a case of this nature. Throughout time, children have been victims of adults. We all know that. But in the 1970s, Senator Mondale, who later became Vice President Mondale, learned how to use that fact politically. He created what is called the Mondale Act. What he learned was that if you were for increasing the budget for the Department of Defense, you'd win some votes and you'd lose some votes. If you were for increasing welfare payments, you would win some votes and you would lose some votes. But if you were against child molestation and hard on child molestation, you win votes and you win votes. Out of that political reality came the Mondale Act. The act was very well intentioned and has done a lot of good, but it has also had some extremely adverse effects. The law requires that there be mandated reporters. Doctors, ministers, psychologists, psychiatrists used to have a privilege, and if they received information from you, they would not report it. The law changed, and there was an exception written into the privileges for child abuse and child molestation. A doctor, minister, psychologist, psychiatrist, etc. is now mandated to report it. If they fail to report it, they can be criminally prosecuted. On the other hand, if they do report it, and let's say they were negligent, they do great harm, the fact of the matter is they will be given civil immunity. Civil immunity means that they cannot be sued. With the carrot and the stick being that they will be prosecuted and the carrot being that they will be protected from civil lawsuits, people report even frivolous cases. After the passage of the Mondale Act, millions and millions of cases were reported. That is what created this hysteria about child molestation allegations and child abuse allegations. The second negative effect that came out of the Mondale Act is that enormous amounts of money were provided for district attorneys to prosecute these cases. Do you know how much was given to the defense to defend against false allegations? Nothing. Not one dime. There was a total imbalance of power because all of the funds went to the DA, special teams of DAs to prosecute, to DA expert witnesses for the prosecution, and on and on. The next thing that occurred was that we got a series of biased, one-sided laws. These have been passed every year since the Mondale Act. Also, in order to prosecute these cases, a whole field of what you would call junk science has been developed. Mental health professionals and medical professionals who have the answers to how you can find out which cases are true and which are false. Most of these theories were not based upon valid research, and this led again to easier prosecutions, but a lack of accurate prosecutions. To overcome this imbalance of power, the one-sided and biased laws, and the junk science that developed around this area, we created our own team. This team specializes in nothing but these types of cases, and by specializing, we're able to level the playing field and even turn it into our client's favor. I have several immediate warnings I want to give you that will protect you from what's to come. The first warning is a concept called the pretext phone call. The pretext phone call is when the police have a child or a relative of the child place a phone call to you. The theory behind it is that the police want to get to you while your guard is down and get you to confess to something. While the phone call is being made, it's normal practice for the police to be sitting there feeding questions written down on pieces of paper to the individual who placed the phone call. The concept is okay, and it is legal. However, it is misused. Think about getting a phone call from somebody that says, "You abused me. If you say you're sorry, I won't go to the police." Well, that puts enormous pressure on somebody who's innocent to say, "I'm sorry." In that way, it's over, and they don't have the police involved. However, when those words, quote, "I'm sorry," close quote, are later played back to a jury, it's going to sound like, "I'm guilty." What we recommend is that if you get one of these calls, just say no, nothing happened, and hang up. You do not want to spar with the cops that are on the other end of that phone call. Stay away from it and immediately call us. The second warning is that at any time you're going to be subject to a search and seizure. A warrant may be issued and your house searched, your car searched, and your computer searched. If this should happen, do not interfere with the police officers. You do not want charges of obstructing a police officer to complicate this matter. The third warning has to do with talking to the police. Most people believe that if you don't talk to the police will think you're guilty. Well, it doesn't matter what they think. What matters is the evidence. The police have been trained in a process called the Reed method of interrogation. Now, you haven't heard about that before, but let me tell you this. Back in the 1930s and 40s, the police could beat you with a rubber hose to get a confession. The Reed method of interrogation is a psychological rubber hose. You can be beaten with that psychological rubber hose, and I guarantee you that you'll confess to killing your mother, even if she's still alive. It's that powerful. That is why we tell people, do not be interviewed. Do not be subjected to an interrogation. Ask for an attorney. Assert your rights to remain silent. You should do that whether you're guilty or innocent. What comes out of those interrogations can hurt you even when you're innocent. I want to explain to you what we call the three-ring circus. Sometimes false allegation cases have to be defended in several different areas. That is why we call it the three-ring circus. In addition to defending yourself in criminal court, in some cases, a spouse will begin a divorce case at the same time. Divorces are considered civil and are litigated in the family court. In addition to your criminal defense, the state may file a petition to stop you from having contact with your children. This may be litigated in the juvenile court. Also, if you're a licensed professional, like a physician, a dentist, a nurse, a psychologist, or a therapist, the state may also file against you in the state's licensing administrative court. You can see why we call this the three-ring circus. Sometimes there's even a fourth or even a fifth ring in the circus. And you must remember, in some states, the government may seek to have charges filed against you in a criminal court, the juvenile court, and in licensed administrative courts all at the same time. In our experience, this teaches us that the prosecutor's office will do just about anything to pressure you to settle for a felony prison term. Obviously, few of us have the funds to fight all of these battles at the same time. That is why these tactics by the prosecution are so effective in compelling the defendant to make some kind of plea bargain to end the suffering. We recommend damage control, or what our emergency room colleagues might call triage. This means that you must pick the battle that is most important and put all of your resources into that fight. We believe that this is always the criminal court. Why? Because you cannot visit your children from a prison cell. You cannot enjoy your marriage from a prison cell. You cannot practice your profession from a prison cell. At the same time, we believe that you must use a defense team that is completely aware of what the standards are in the family law court, the juvenile court, and the state's administrative court, and is able to assist you in those courts also. It is important to make sure that whatever is done in any of these other courts does not hurt your criminal case, and vice versa. This is just another reason why we have experts in our group in the area of family law, juvenile law, and state administrative hearings. I want to talk to you now about how biased and unfair the law has become. Let me give you some examples. We used to have a preliminary hearing. This is a hearing that's held prior to the trial, where a judge decides whether or not there's enough evidence to warrant even having a trial. We used to be able to call witnesses at that hearing, and it gave us an opportunity to question the accuser. Well, what happened is in the McMartin case, the preliminary hearing lasted about a year and a half. Most preliminary hearings last a day or a day and a half. The prosecution put a proposition on the ballot to change that, and now they don't even have to call the child in one of these cases. A police officer can get up and testify at the preliminary hearing on behalf of the child. Further, we cannot call witnesses. We used to be able to. So if there was a reluctant witness who wouldn't talk to our investigator, we could put them on the stand at the preliminary hearing and learn what they had to say. Now we can't do that. The next law that is really unfair has to do with sentencing. The acts are parsed down into individual little components. Let's say a child molestation carries 8 years, and the child says, well, he touched me on the left breast, then he touched me on the right breast, then he touched me on the vagina, and then he touched me on the left breast again. Well, there's 4 counts at 8 years apiece, and that took about 15 seconds. That is why you hear about sentences of 400 years and up. The law is designed to usually require that each act be served consecutively and not concurrently. Time the judge's hands, which means that you add one sentence on top of another for each count. Each year there are more and more laws covering this area, and they are designed to make it easier to prosecute and require more severe punishment. For example, people who would go to state prison get 50% credits for good time work time, but not for sex cases. They have to serve 85% of their sentence. That's an effective increase of 70% more than you would spend in prison, even though there's been no change in the law having to do with the length of sentence of each count. What else has happened? Discretion is being taken away from the judges. Most allegations can be filed as mandatory prison sentences, with just a few exceptions. If force or duress is used, you can get a mandatory prison sentence. Well, when the legislature passed the law and it said child molestation with force, I think they were thinking about real force. Well, the Court of Appeals has stepped in and interpreted what force means. And basically, it's the physics definition. You know, if you push a penny across the table, that takes force. The cases that I've seen, there is only one case that is held not to be force. And in that case, the victim said that she opened her eyes and a penis was in her mouth and it was pulled out. And the person didn't touch her with his hands in any way. Held no force. However, there are cases where somebody was led down the hall by the hand. Held to be force. A case where somebody was placed on the bed. Held to be force. A case where somebody put a hand on the shoulder to guide the head of the child towards a penis for oral copulation. The placing of the hand on the shoulder was held to be force, and that made it mandatory state prison. But what's duress? Duress is another way you can get mandatory state prison. Duress is when you're forced or threatened to do something. You know, if you don't do it, I'm going to kill you, that type of thing. Then the Court of Appeals got involved and started interpreting what duress means. There's actually a case where it came down to, well, he was big and I was little, and I felt intimidated by that. So mere difference in size has been held to be duress. You've heard about the 3 strikes and you're out law? Were you aware that there's a 1 strike and you're out in sex cases when you have penetration with force? 1 strike and you're out. 25 years to life. The other area of imbalance in the law that has developed had to do with the evidence code. We've spent hundreds of years developing the evidence code based upon only allowing an evidence that's reliable. Well, they've made a series of exceptions to the hearsay rule to assist in prosecuting these types of cases. If a child tells a doctor what happened and the child's statements are used in his diagnosis, the hearsay statements are admissible. It doesn't seem to matter that there is no such thing as a diagnosis for sexual molestation. Remember, sexual molestation is an event, not a medical exception. That's an exception to the hearsay rule. They just made one after another, exceptions to the hearsay rule. But no exceptions have been made to help the defense. The Supreme Court in Crawford versus Washington has placed some limits on the ability of the state to make hearsay exceptions. The next thing is that for over 250 years, propensity evidence has never been allowed into evidence in the state of California. Propensity evidence means that you did something similar to this in the past, therefore you must be guilty of what you're currently charged with. What the courts found was that people would be convicted for their history rather than for what currently occurred. The courts found it to be extremely prejudicial evidence, and it was never allowed in. Well, guess what? A new law has passed which allows in propensity evidence in sex cases. We also have sex registration. That was a good idea when it started. The police would have a way of keeping track of everyone, but every year that law has changed. At first, you had to register once where you lived, and you didn't have to register again unless you moved. So if you owned a home and stayed there for 30 years, you didn't have to register again. They then changed it, and you had to register within 10 days of your birthday every year. And if you don't, you're going to go to prison. Then they changed it again and said that if you're out of your domicile for 4 days, you have to register. Now think about that. That means if you go on vacation to Hawaii for a week, you have to run down to the Honolulu Police Department and register as a sex offender? That puts a little damper on the family vacation. The last thing, and the one that I think we're going to be struggling with for years to come, is Megan's Law. It used to be that the police had access to this information. Now this information is available at every police station for public viewing. The problem is that if you ever get put on registry, where do you live? They tell your neighbors. Where do you work? They tell your employer. Every year, more and more laws are passed, and they are always designed to help the prosecution and to strip away the rights of the defendant to defend himself. Another thing I want to mention is the sexually violent predator law. After you have finished serving your complete sentence, they can now transfer you to a mental hospital. But the mental hospital has wires around it, cells, and it looks exactly like a prison. The theory behind it is that it's a civil commitment. If you have somebody who's insane and going out and going to kill everybody with an axe, they can be put inside of a mental institution while they're recovering their sanity. Well, here, they're saying that you're still a violent and dangerous sexual predator, even though you've served your complete sentence. So we're going to send you to a mental hospital. It's a one-way ticket. Very few people ever.
In 1974, until I retired, I was a detective in the Riverside County Sheriff's Department assigned to the Crimes Against Pattern Analysis Unit, Law Enforcement Intelligence Unit, and the Crimes Against Persons Unit. Allegations of child sexual abuse and child physical abuse are handled by the Crimes Against Persons Unit. During this time, the country was rocked by sensational cases such as the McMartin preschool case and the Bakersfield sex ring cases, and many more. These cases were based upon investigations that went out of control. Fortunately, we didn't have problems like this in Riverside County. Certainly, we had our share of accusations. So how did we avoid these types of problems created by investigations that went out of control? Command instructed us to do investigations as if we were defense investigators. That's right. I was told to conduct my investigations as if I was the defense investigator. If you're searching for the truth, you must be as concerned about those that are innocent as you are about those who are guilty. This attitude helped us avoid approaching a case with a single hypothesis and motivated us to explore other possibilities of how something could have occurred. Today, as I do investigations for the defense, I'm encouraged by law firms I work for to conduct an investigation if I were the police. Why? Because good defense attorneys are concerned with what is out there and what facts a good investigation will uncover. Good defense counsel want to know what is out there that can affect their case, and they want to know it as soon as possible. Today I want to talk to you about what a competent investigation entails, whether that investigation is conducted by law enforcement or by the defense. The information I'm going to give you today comes from, in large part, the presentation that I give to law enforcement when I do training programs for POST, Police Officer Standard of Training. It doesn't matter what the audience is made up of, law enforcement professionals or defense investigators, the message is the same. Search for the truth. The investigator is supposed to be the finder of fact in the search for the truth. It's important that the investigator assist the attorney at trial, whether that attorney is the defense attorney or that attorney is the district attorney that the investigator is assisting. The assistance is based upon the investigator's search for the truth, and in the search for the truth, reliability is the key. For us, reliability means, 1, are there sufficient corroborating facts supporting a conclusion? 2, will it hold up to scrutiny? 3, will it hold up over time? It is important to understand that when any investigator looks at a case, they want to be concerned with the reliability of the information contained in the case. Bias affects that reliability. One of the most important kinds of bias an investigator needs to watch for is called confirmatory bias. In its worst form, this means driving towards a specific conclusion, no matter what the evidence may be. Confirmatory bias is widespread. It can be overcome only with specialized training. It is especially important to learn to ask the right questions. We must guard against focusing only on "he did it" or "he didn't do it" kinds of information. We can guard against confirmatory bias by trying to look for the whole picture. Number one, who made the initial allegation? Number two, what were the circumstances of the initial allegation? Number three, who stands to gain by the allegation, and so on. This is the groundwork an investigator will lay down to help guard against confirmatory bias. We must also consider coercion. This can mean manipulation by someone with something to gain by the allegation. It can mean an overzealous interviewer mishearing a child, or worse, it can mean covert threats, which almost any investigator will work to uncover. Investigators should carefully review audio and videotape interviews, whether they be of witnesses, or the victim, or the suspect. I teach that good investigators must interview the suspect concerning the circumstances and his state of mind during any admission or confessions he may or may not have made, either in the interrogation arena or in the pretext arena. The pretext arena refers to pretext telephone calls made by the alleged victim to the suspect that is recorded by the police investigators. An investigator must carefully review the circumstances and the state of mind of the defendant in both of these areas to uncover coercion, misinterpretation, or misunderstandings. We find that chronologies and witness lists are of great value. It is the client and the investigator that put the chronology and the relevant facts together for the attorney. This helps create a context for events and serves to guide the investigation and the trial preparation. This is of great importance because absent the context of how something occurs, it's very difficult to form an accurate picture. Another important factor in any good investigation is to develop evidence on the credibility of all witnesses. Do they have any motives to lie? Do they have any motives to get back at someone? We also take a look at issues of source monitoring, and this generally means to the source attribution and source misattribution. Dr. Larandos tells us more about this in the seminar on suggestibility. Let me just say that source monitoring refers to the process of identifying the origin of one's knowledge of events. Maybe someone has a memory, but did that memory come from an actual event, or from just thinking about that event, or from the event being suggested to them? My friend Dr. Elizabeth Loftus has done a great deal of important research in this arena, and a great deal of that research is presented in the seminar on suggestibility. It is also important to remember that as people, we tend to look for things that support our own personal point of view. As investigators, we must look at prior interviews that have occurred for indications of such bias. These indications are sometimes apparent because of the complete lack of prior interviews or any attempt to think about or search for any alternative hypothesis. Remember I talked about guarding against focusing on only "he did it" kinds of information? It's crucial in a good investigation to determine whether interviews looked at any alternative hypothesis other than "he did it." We look for, as we say in psychology, the pursuit of alternative hypotheses. Are there other possibilities of how this event could have occurred? In general, we try in our interview process to examine other possibilities. The investigator will also consider confessions and ask, do you have any coerced confessions? Professor Leo has spoken a good deal about this. I would add that the objective investigator will not take a confession at face value, but will investigate whether the suspect was scared, or look into the possibility that maybe they said what they said because they thought it would help them with less jeopardy. We must also look for factual disclosure that only a person that is guilty would be aware of. These are but a few of the important issues for psychologists and good investigators to answer. Let me also say that we must carefully look at the medical reports. Medical reports may or may not confirm that which is. We know that a good investigator will investigate issues of opportunity, motivation, and sexual knowledge. It's how an investigator looks into these important concerns that I want to talk about now. When conducting interviews, the skilled investigator will be concerned with the reliability of the information provided. There is significant research regarding the issues of memories and malleability of memory. One of these important malleability issues is coercion. An investigator should work to determine if coercion was used with any witness, and if so, as a result, the individual may assent or accommodate and give the story that they gave to minimize the possible negative outcome. The concerned investigator will also work to determine whether the information provided by any of the witnesses or victim was based in any way on the suggestibility of that person. Also, the investigator should look at the possibility of implantation of non-events. Analyzing interviews, the objective investigator will look at issues of
In the mid-1980s, Dr. Bruce Woodley, a pediatrician from San Luis Obispo, published an article on the signs of molestation in genital and anal exams. The local district attorney sent children to Dr. Woodley that were suspected of being victims of molestation. Dr. Woodley examined them and found erythema, which means redness, a rounded hymenal edge, rounded rather than a blade-shaped edge, bumps on the hymen, increased vascularity, and indents in the curvature of the hymen. He concluded that these and other signs he noted were proof of molestation. His work spread across the country and became accepted dogma. It was total junk science. Why, you say? Because no one had ever done a study on normal, non-abused children to establish what was the range of normal anatomy of non-abused children. If you do not know what is normal, you cannot know what is abnormal. In the early 1990s, the first controlled studies were done. And what did they find was normal? Erythema or redness, rounded hymenal edges, bumps on the hymen, increased vascularities, indents in the curvature of the hymen, and on and on. What Dr. Woodling had described as signs of abuse were in fact normal anatomy. Now the examination of children has turned into a word game. The doctor examines the child and says, quote, "The findings were consistent with molestation," close quote. Most people, the police, and jurors believe that that means that they found evidence, but not so fast. Doctors may have a long list of findings of erythema, increased vascularity, etc., which are totally normal. But most times they have found nothing. So why has the prosecution doctor called it, quotes, consistent with molestation, close quotes? Well, you can touch someone on the vagina and leave no evidence of trauma. Therefore, no evidence of trauma, or no evidence at all, no evidence of a medical sort, is also consistent with molestation. Using this play on words, every child in the world has anatomy that is, quotes, consistent with molestation. To counter this junk science and the word games played by advocacy doctors, we call on our own experts. Maintains a library of controlled studies on normal genitals and anal anatomy. The following is a clip from one of our training videos that we use to train judges and attorneys about this area of medicine.
These photos depict some of the findings that the McCann team found. They did a study of non-abused children to establish what the norm was. What they found was 41% of the children had erythema or redness. For years, doctors had been testifying that evidence of erythema or redness was proof of molest, and yet the McCann study established 41% of non-abused children had this condition. It went on to find that 26% had areas that looked like scars but were not. These scars appear like a thin white line in the skin, and when they saw them, what they found out was that they were created by a genetic abnormality under the skin and were not actually scars. But for years, people had been looking at them and thinking they were scars and testifying that they had found evidence of molest. Remember, 26% in non-abused children. 44.8% total had projections or tags on the hymenal edge. That means instead of the edge of the hymen being smooth all the way around in a crescent shape, there would be a little indentation or a bump sticking out from the edge. For years, people have been testifying that this was evidence that a molest had occurred. They actually found out that 44.8% of non-abused children had these projections or tags. The study went on and found 69.7% had thickened or rolled edges of the hymen. An edge of a hymen comes down like a blade. It becomes thin and sharp at the edge. Some of them, however, were rounded, and they had felt for years that this rounding was caused by abuse because of penetration. In fact, it was not, especially when you found out 69.7% of non-abused children had this thickening or rolled edge of the hymen. 31.3% of the McCann study children had increased vascularity. It means you could see vessels, blood vessels, near the surface. For years, doctors have been testifying that this was evidence of sexual penetration. In fact, it turns out it is not. Again, 33.1% of non-abused children have this. Another phenomenon was for years people have been testifying that if a vagina ever exceeded 5 millimeters in diameter, that was a sign of penetration or sexual molestation. In this study, they found vaginal openings varying up to 8 millimeters. They even found a few above that, but they discarded those as scientifically insignificant in numbers.
We get numerous telephone calls wanting to know whether or not we recommend taking a police polygraph when the police call and offer you one. We believe that police polygraph examinations are not reliable. We don't need to get into the scientific discussion as to the reliability when an example will suffice. We have had clients that have taken 2 polygraph examinations. Our examiner is the individual who trained police officers throughout his career at the California Department of Justice and later retired. He now does private polygraph examinations. We have had cases where our examiner has passed the person and found them to be not deceptive, while the police department examiner, who is trained by our examiner, found them to be deceptive. Why? We have also seen certain police examiners that never find that anyone passes a polygraph. They always find that the suspect is deceptive. Further, many prosecutors are not moved by a favorable result on a polygraph machine. They only believe the results if they point towards guilty. Why? Well, they have explained it to us that psychopaths have no conscience and therefore demonstrate no stress when they're lying. They believe that a pedophile is a psychopath who can pass a polygraph. If the suspect flunks, they believe the result. If the suspect passes, they don't believe the result. However, nothing is absolute, and on a few occasions we have had cases dismissed upon polygraph examinations. With some lawyers, if the client takes a polygraph and fails it, there is a tendency to stop preparing the case because of the belief that the client is guilty and the case should be plea bargained. At the very least, the attorney does not have the zeal that he or she might otherwise have had. Further, the client may become afraid that the attorney doesn't believe in the case and will not try as hard. There is a breakdown of trust in the attorney-client relationship. With police examinations, too often the polygraph examination becomes a ploy used as part of the interrogation process. This is how they are trained. It is the questioning of the client before, during, and particularly after the polygraph examination that they want. Even if the person passes or it's inconclusive, the officers are allowed to lie. They can tell the suspect that they failed the polygraph examination and then ask the suspect what could have happened that would have caused that. Maybe you accidentally touched her, something to that effect. The polygraph examination is literally used as a psychological ploy to apply pressure to extract some sort of an admission. We would recommend that you not take a police polygraph examination. If you want to have a polygraph examination, you should go to a private, reputable polygraph expert. I'd like to talk a little bit about the philosophy of our group. In cases such as these, the prosecution has a 98.5% win rate throughout the country. The defense wins at about 1.5%. Now, that's not our win rate. We have a 40 to 60 times higher win rate. Why is that? Well, a public defender handles 350 cases a year. Now, with 220 workdays in a year, you can imagine how much time they spend on an individual case. Now, serious felonies get less than an hour of time from the public defender because of this incredible workload. Now, for private attorneys, they typically handle 80 to 120 cases a year. Why? Because they're trying to pay for those yellow page ads. They take a lot of cases in and they plead as many of them as possible. They get a retainer and then they bargain with you and with the prosecution as quickly as possible so they can move on to their next retainer. You cannot evaluate a case until it is prepared for trial. Let me give you an example. I had a case of a grandfather who was charged with a molestation, and the prosecution thought he was guilty. Our investigator had met a Catholic priest, and he believed that the priest had information about the case, but the priest wasn't talking. Our investigator kept going back over and over and over again. On the fourth day of trial, the priest finally broke and turned over letters that had been written by our client's granddaughter. And in those letters, she said that she had sex with over 40 men in the congregation. Previously, she had been saying that she was a virgin and that the only person that she had been involved with was her grandfather. She was caught lying and making up stories. The charges were dropped on the fourth day of trial. This is the kind of tenacity we bring to continuing litigation. It is also an example of why you cannot evaluate a case until it is completely prepared, until you have all of the answers. This is the kind of tenacity that we bring to continuing litigation. We believe that the preparation must be completed before any decisions can be made about the case. We handle only 8 to 12 cases a year, and perhaps a couple of small cases that we have a special interest in. Our preparation begins on day one. We scan in all the documents, we index all the documents, we capture all audio tapes, we capture all videotapes, and they are put on our computers electronically. We prepare transcripts of all of these tapes. We prepare clips for presentation during trial and during the closing. We have a jobs list where we make a list of everything that we are going to do and the job assignments for every other member of the team that is going to work on the case. We have a chronology that we develop, which we primarily get from you, and we update consistently, telling us absolutely everything that happened in chronological order. We make a witness list while we are receiving these documents so that we can contact every person that is mentioned in any report that may be of any value to us. The reason for this? You can be reading on page 65 and it mentions a janitor who is not involved in the case. And on page 650, you can read about the janitor and now he's become a key witness. How do you go back and find that address that was on page 65? You can't. So we keep track of all addresses as we see them, as we run across them, along with phone numbers and other contact information. We make an outline of every witness's testimony. We do not wait to a week before trial. We begin the very first reading of the case making these outlines. All of these documents, a jobs list, a chronology, a witness list, and outlines for witnesses are all prepared at the same time. We call it multitasking. It's extensive preparation that wins cases. Now, we can teach you everything that we're going to do on your case so that you are an equal partner in the preparation of your case. And we insist that you remain so. Remember, it's your case. Now, the prosecuting attorney will make offers whether or not you want them to. Our job is to make sure that you make an educated and informed decision on whether to accept any of these offers or whether to go to trial. remember, there is hope. Many clients ask about coverage in their area of California. Simply put, we handle cases all over California. Our team members appear in every California county and have done so for years. We keep connected to our office electronically over the internet through PC Anywhere and other computer programs. It's easy to get around the state of California. With the use of Southwest Airlines and United Airlines, we are linked to all of California. Besides being linked to our own data files and research, our experts, our investigators, and all members of our team are also connected over the internet. This allows our team members to have instant access to all the materials that they need, no matter where they appear in the state of California. Sometimes people will say, well, gee, there's an attorney here locally who says he knows the judge, wink, wink. Well, I've never seen a judge or a DA give away the case because of friendship. But what I have seen over and over again is that when we appear in the courts, we're prepared, we have our investigations done, we have our motions done, and we know what we're doing. Within the first day, the judges have gotten to like us because they recognize quality presentations, and that's what they're interested in, and that is what they're interested in. We know that you are located in another state. You need to know if our team can come into your state and represent you. Of course we can. Our team members practice in every state on a case-by-case basis. This is a procedure called pro hac vice. This means that an out-of-state attorney presents his or her credentials to the local trial judge and requests to be allowed to practice just like a local attorney in your area for just your case. In fact, the U.S. Supreme Court has encouraged this practice. Why? So that people can get an expert in the field that they need, because many times these experts are not available locally. When we practice outside of California, we always work with a local attorney. This helps us to make sure that all local rules for your state and your county are followed. We have in our office the law of all 50 states, federal and military, so we are able to represent you in any of these forums. Now that you know the politics cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist, and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published Cross-Examining Experts in the Behavioral Sciences, and he also published Bench Book in the Behavioral Sciences, Psychiatry, Psychology, and Social Work. What these two books do is train lawyers how to cross-examine experts. It also trains judges. That's what Bench Book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. We're known for being a big case firm. We don't go to court with 10 files under our arms, as you'll see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There's a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in case. In 1985, there was only about 1 line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell.